As I indicated, the final case set for argument this morning is AR&AR. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you would like to reserve time, let me know and I'll give you an idea where you're at as you approach your deadline there. The arguments are recorded and are posted on the court's YouTube channel, so please remain behind the podium and keep your voice up. And because the arguments are recorded and posted online, we ask that you refrain from using the names of children or victims during your presentation. Though, as I call the case, we prefer to use just the initials, in this case AR and AR. The panel has read the briefs and we are ready to proceed if you are. Counsel for appellant. You may be, we use the front podium, I assume everybody knows.
Thank you, Your Honor.
Would you like to reserve time?
Your Honor, I would suggest 5 minutes.
5 minutes.
For rebuttal.
I'll let you know as you approach that mark.
Thank you. Morning, Your Honor.
Morning.
Joseph B. Rose on behalf of the appellant, Mr. Robert Redizak. Let the record reflect that while we have succinctly set forth our arguments and our objections to the magistrate's decision, our oral argument before Judge Janik, and our briefs, there are a couple of issues I'd like to highlight that we've raised. I believe we're all in accord that the ultimate issue here is the best interests of these two children. From their father's perspective, he asks, how can it be in their best interest when there is custody of them by a liar, a prevaricator, and a perjurer? I believe the record is clear that Karen Balzer took an oath and then purposefully misled the court. She did it to gain custody of my client's children and to push them out of their lives. In fact, she poisoned the entire process. Besides lying to the court, it's apparent that she lied to the lawyer. Puts him in a very difficult position. Her attorney would never have allowed her to testify in November at the emergency custody hearing if he knew that she was going to provide false testimony. He never would have permitted her to testify in the March hearing if he knew that she was going to provide false testimony. But you can't have it both ways. She did a complete 180, and there's no question but that she lied at least one of these hearings, possibly both, but we can document at least one. She submitted a parenting affidavit and then testified that she didn't know and didn't recognize the writing on that parenting affidavit. You know, she didn't do it. In fact, she testified that she didn't even read it. Well, quite frankly, if she didn't fill it out, who did? And unfortunately, we were precluded from ascertaining that by the magistrate. She lied to Jennifer Stopper, who's the caseworker for the county. Ms. Stopper appeared stunned at the March hearing when Balzer testified that she was not present made a disclosure allegedly to her that her dad had touched her improperly. She lied to Attorney Otero, who's the guardian ad litem. On cross-examination, Mr. Otero asked her relative to a discussion that he had had with her in his office just 2 weeks prior to the hearing. He said, "Did you not tell me that one AR made a disclosure in your presence? Answer me yes or no." The response, "I did not tell you that." I'm not a psychiatrist, but is she delusional or flat out lying? She lied to Consular Arroyo. Consular Arroyo testified that she was very surprised when she was informed that Ms. Balzer testified that she was not present when this alleged disclosure was made. She also testified that she was aware of allegations that a 6-year-old maternal cousin of A1R, had inappropriately touched her, for lack of a better word. However, she never got to investigate that allegation due to the fact that Ms. Balzer told her that it was a done deal. There was no evidence. When in actuality, the evidence was that A1R informed my client and his sister Renee that this 6-year-old had improperly touched her. I don't know what she said to the state, but she testified at the March hearing that she had sufficient means to raise these 2 young girls, when at the same time she was collecting welfare. Ms. Balzer has claimed that she can take care of these children. She has testified that she's concerned about their health and their welfare of my client's children. Yet the record reflects that she failed to inform him that his daughter, who was under her care, had a urinary tract infection. Not only did she not inform him, she failed to provide the medication for this little girl when he picked her up for his time with her. Upon my cross-examination, her response was, and I quote, "It's not her responsibility." It is obvious that at some point in time, everyone that testified on behalf of Ms. Balzer, at one time or another, relied on what she told them in formulating their opinions, and in formulating and directing their activities. This is the same woman who was employed by Our Lady of the Wayside, who is a very, very well-known care-providing agency. It was her last job, and she left, according to her testimony, because of differences. We don't know what those differences were, because when we attempted to ascertain why she left this care-providing agency, we were precluded from inquiring by the magistrate. We submit that Ms. Balzer's blatant duplicity was not even acknowledged, let alone referenced, its face, the magistrate in his decision gave absolutely no weight to the evidence we submitted in this case, and particularly in that regard. Zero, none. We submit to the panel that this is reversible error. Sadly, this emanated from the same magistrate that at the beginning of the hearing in March stated it would be his pleasure to hold Mr. Radizak in contempt. I might address the elephant in the room. My client did not molest his daughter. Point of fact. Ms. Balzer has and had complete custody and control of my client's children. She's had that control with her family since October 29, 2017. We're all aware of how impressionable and pliable young children's minds are. And I'd like to stress that these allegations of sexual impropriety, this is the very first time that these have ever been or ever arisen.
You're at 5 minutes now. You may continue or
I'll continue.
if you, okay.
What happened was A1R confided in Renee, Mr. Radizak's sister, and my client, that she had been inappropriately touched by her cousin. 2AR had severe blisters, diaper rash. Subsequently, Mr. Radizak and his sister took these children to Dr. Lorain, who was a pediatric specialist who was originally the child's doctor. They asked Ms. Balzer to present the children at that time. She refused. Dr. Aurora suggested that the children be taken to University Hospital if this continued. The children were taken to University Hospital. Father and Ms. Radizak, his sister, appeared at the hospital where there are doctors, nurses, trained professionals, security, police officers. She said, please help my daughter. He put his daughter in their good hands. Why wouldn't he? He didn't do anything wrong. Does this sound like a man that has something to hide? You put these children in the hands of these folks who can interview them, talk to them, who are trained professionals. He had nothing to hide because he didn't do anything wrong. October 29th, in accordance with the court's order, he returned the children to Ms. Balzer. Ms. Balzer found out that there were allegations made against her nephew, great-nephew, grandnephew. And keep in mind that she had exclusive control and custody of these kids. After 9 days, voila, there was a declaration by the young girl that her father had inappropriately touched her. They immediately moved for emergency custody. At that hearing, which we certainly, whether to attend didn't even know about, there were several instances where Ms. Balzer flat out misled the court. The court indicated that predicated upon the testimony of Stopper and Balzer, that Balzer then had custody of these kids and she's had them ever since. These allegations are totally uncooperative. There's no physical evidence. There's no time frame as to what they happened. We're all aware that the court can draw inferences relative to factual situations, and this factual situation cries out for an inference. There is no question that Ms. Balzer had the motive, the means, the opportunity to convince and coerce this young girl to make these allegations that had never been made before.
minute and 50 seconds total time left. I don't know if you want to reserve any for rebuttal or not.
I'll reserve that for rebuttal.
All right, very good.
Thank you.
Now, how do you want to split your time? Are you both going to argue, or?
We would both be presenting, Your Honors. If you could inform me when we have 5 minutes remaining.
You want the last 5 minutes?
Yes, Your Honor.
Okay, I'd be glad to do that.
Thank you very much. May we please come forward? Your Honors, here on behalf of Karen Balzer, appealee in this matter, as this court has already stated, I know you've reviewed the record, you've reviewed the briefs, certainly based on some of the statements made by Attorney Rose and his arguments. There are some points that I believe would be imperative to bring forth in this matter. Most importantly, I believe, as we're dealing with our standard review here, is the manifest way to the evidence. Realistically, this court understands that a manifest way to the evidence means that the magistrate and then the judge needed some competent, credible evidence to rely on. And the standard for legal custody or for the disposition order is preponderance of the evidence. So essentially a greater weight of the evidence here. So we believe undoubtedly that after multiple days of trial, the greater weight of the evidence showed that legal custody to Karen Balzer was appropriate in this manner. Interestingly, a great deal of father's brief and objections kept going back to this issue of a parent versus non-parent. In the reply brief, I do believe it was essentially conceded that there's not an issue. I know that Attorney Rose, on behalf of his client, continued to state that the adjudication dealt with mother and not with father. The record shows there's an adjudication of the children. The parents aren't adjudicated, it's the children that are adjudicated. So as this court's aware, and as Attorney Rose stated at the beginning of his argument, what we're left with here in a determination of it is simply best interest. There's no need for unfitness at this point in time. It's very clear that post-adjudication best interest is what we need to reach a conclusion here. The best interest factors in legal custody are not specifically set forth. And there's some guidance provided regarding the best interest factors for permanent custody. These are a little bit different than the 310904 best interest factors in private custody matters. Those certainly the court can consider those factors as well. I will go through those factors shortly and show that I believe that the court had competent, credible evidence in support of those. What I believe at the crux of this case is Mr. Rose continues to show Ms. Balzer and some inconsistencies perhaps in her testimony. Certainly when people take the stand, some people perform well, some people don't perform well. That certainly goes to the credibility of the witness. It's the trial court, in cases whole over and over again, that has that determination. They have the better ability to observe those witnesses, to determine the credibility, to hear those statements, the inflections, perhaps any intonations, physical gestures, etc., to be able to make those determinations of credibility. The court heard all of that. The court heard Ms. Balzer on both occasions. This case, in my estimation, doesn't hang on Ms. Balzer's testimony, quite frankly. Ms. Balzer never testified that this child made a direct disclosure to her. The testimony dealt with whether or not she was present when the child made a disclosure to Jennifer Stopper, the caseworker from Children's Services. Ms. Balzer had multiple opportunities. She has these children a majority of the time to come up with and contrive that this child had made a disclosure. She didn't say that. She did state she was present, and Ms. Stopper's testimony actually confirms that. It confirms, though, that Ms. Balzer was somewhat in and out of the room and around the house when the child made the disclosure to Jennifer Stopper. Jennifer Stopper also testified at that emergency custody hearing, that ex parte hearing. So the court wasn't simply relying on Ms. Balzer, it was certainly there. Additionally, a disclosure was made to Abigail Arroyo, the counselor, for 1AR. Through the pendency of this case, Ms. Balzer did not come in and say, after she said this to Ms. Stopper, she continued to say this to me. She hasn't fabricated that. The two disclosures are to these professionals. If Ms. Balzer was looking to create this fiction, it certainly would have been easy, especially with father out of the picture and the children with her 100% of the time, to say at any point, oh, you know what, and now the child's made a disclosure to me. That hasn't happened. Additionally, what we have in this case, and the court certainly relied on, was a guardian ad litem. Attorney Otero is a guardian ad litem historically throughout this case. He's familiar with some of the obstacles that this case had leading up to the co-custodial parenting plan that was in place. He met with the parties, and certainly in reflection, the testimony, I believe he even said that he had some questions or concerns, but he sat through all of the testimony. He heard Karen Balzer testify in her entirety and still made the recommendation for legal custody. He still made a recommendation that dad's parenting time be suspended or terminated, not only over the course of his investigation, but in hearing all of the evidence that was presented. Yet, witnesses that testified, say, favorably for father, certainly had credibility issues of their own, certainly based on inconsistency. 2 siblings and a friend who he'd worked for. Clearly, the court could determine perhaps there's a bias. Even without finding a bias there, the 2 sisters were inconsistent in their testimony. There was some testimony regarding a very substantial blistering diaper rash. I'm not sure of the parental status of the court here. I have 5 children in my home myself, and their children get diaper rashes, but I don't know that I've ever described any of my children's diaper rashes as blistering. That's pretty significant. That would be very alarming to me as a parent, aunt, uncle, individual. The 2 children are certainly very different in age. 2AR is a baby. I mean, very, very much toddling. I don't think that there's a confusion, and it was a point that was brought home. I wanted to make sure in cross-examination, because the distinction was so apparent to me in the given testimony over which one of the children were suffering this blistering rash. It was completely inconsistent. Additionally, there's testimony that the children would come over and they were unkempt and unprovided for, except that Clifford Wise, who testified on behalf of father and in the history of the case had been a supervisor, said the exact opposite. Yeah, I've seen these children on multiple occasions. I've come over, I've supervised them. They were always clean, they were well groomed, they were well taken care of. I believe all of those inconsistencies certainly would add to the credibility. To reach that this is against the manifest weight of the evidence is essentially to assume that the caseworker's in on it, the guardian ad litem's in on it, and the counselor's in on it. These are 3 licensed professionals who I believe are well respected in their fields, who I'm not aware of concerns, or there didn't seem to be anything brought up at trial or in any briefs regarding concerns of their corruption or fraudulent acts or calling them into question, but I believe that's exactly what we're looking at here if we're to believe that this relies solely on the testimony of Karen Balzer. In fact, without Karen Balzer whatsoever, I believe the court is quite able to reach the conclusion of legal custody. In looking to several of the cases that were actually cited by father, In re TW is a case that I think is very analogous to the case at hand. And in that case, there's allegations of abuse by father against the mother, very similar to our case. A legal custody was granted to an aunt. There was an adjudication. And one of the issues, which was around here, is that a counselor presented new testimony in that case. There was new evidence right before the hearing. The attorney for the father in that case did not object, did not ask for continuance, did not ask to be able to review that. The court held there that absent plain error, that would not be reversible error at this point. In that same case, the testimony, they found it appropriate to award the aunt custody. Similarly, in re KC, there was a caseworker, a psychiatrist, and a guardian ad litem who testified. The court found in that matter that based on the testimony of those parties, that the trial court could reasonably conclude that it is in the best interest to place legal custody with the person they granted legal custody to there. Both of those cases, I believe, would still support the finding legal custody to Aunt Karen Balzer. Looking at the best interest factors to consider.
You've got 1 minute to do that.
Absolutely, Your Honor. Perhaps most importantly, the children have had a long-standing relationship with Miss Balzer. 2AR had been placed with her since about October of 2016. Even though we had a co-custodial parenting agreement, as this court is certainly aware, the legal standing may have been one thing, the children spend a majority of their time with Karen Balder. I believe they spend 5 to 6 nights per month outside of her care in her home. She's continued to provide for them, absent any support financially from mother or father for the entirety of the time she's had the children, which up to now has been nearly 2.5 years. We'd ask the court to uphold the legal custody to Karen Balder in this matter, and turn the remaining time over to Children's Services.
All right,
Thank
that would be 5 minutes and 11 seconds.
May it please the court, my name is Preeti Kishman, representing Lorain County Children's Services. We would agree with all the arguments that Attorney Oliver has made and support those arguments, but I just want to touch on a few other things. We would, of course, ask the court to consider everything that was in the brief that was previously submitted. The trial court's grant of legal custody of the minor children to maternal aunt Karen Balzer was not against the manifest weight of the evidence, therefore it should be affirmed. I think the crux of the appellant's argument is they don't like who the magistrate thought was credible. That's not a reason to reverse the grant of legal custody. That doesn't mean that the decision was against the manifest weight of the evidence. The magistrate was present, he saw how everyone testified, he considered the inconsistencies, and he made a decision based on that. One argument that the appellant made in the brief was that there was not a change of circumstances such that the legal custody motion could be filed. There were the facts that were found by the magistrate made it clear that there was a change of circumstances. There were multiple disclosures of sexual abuse by one AR against father. She disclosed on 2 different occasions. Also, there was evidence from many different witnesses, Children's Services, the guardian ad litem, father, from maternal aunt, that there was a lot of fighting, there was a lot of drama between maternal aunt and father, and that this co-parenting agreement was not working. Additionally, there was plenty of testimony that father was the one instigating this. Specifically, the guardian ad litem testified to that information. Therefore, I think it was clear from what the court found that there was a change of circumstances. Additionally, the appellant argues that this decision was not in the best interest of the minor children. The testimony was clear that this was in the best interest of the minor children. In regards to the relationship between the children and father and the children and maternal aunt, it's clear that children had a better relationship with maternal aunt. The guardian ad litem testified to that. During the Attorney Rose, during the appellant's time, talked about that it's absolutely not true that father molested these children. However, there are a lot of red flags. Father himself testified that he was showering with his young daughters. There was also testimony, or it was clear from the testimony, that father had begun to engage in a relationship with the mother in this case when she was a minor. Is that, absolute, beyond a reasonable doubt proof that something like that happened? No, but we're not dealing with beyond a reasonable doubt. There are red flags here. There are no red flags with Anne. The children were doing well in their care. There was testimony from the caseworker, there was testimony from the counselor, there was testimony from maternal aunt herself, there was testimony from the guardian ad litem. The children were both these children were doing very well and were well bonded to to maternal aunt. Additionally, regarding the wishes of the children, the guardian ad litem testified that both the children were not old enough to be able to explicitly express, but he felt that it was still in their best interest to be with maternal aunt because it was clear that there was a bond there. In terms of the custodial history of the children, they were either through the co-parenting agreement or temporary custody with this maternal aunt since January of 2017. And additionally, in regards to a need for a permanent placement for these, or legally secure placement for these minor children, it's clear that maternal aunt was the best choice for them. All the testimony showed that it was a safe home, it was a stable home. In stark contrast, father's home wasn't secure for a variety of reasons. The sexual abuse allegations was one concern, but also father himself admitted while he was testifying that he had never addressed his mental health. His mental health, it was clear that it does have an impact since he was instigating these arguments with maternal aunt. This was happening in front of the children. That has an impact on the children. There's no testimony that maternal aunt was instigating anything. The two minor children are in a safe and stable home with Ms. Balzer. She's able to meet their basic needs long-term. This decision was not against the manifest weight of the evidence. Therefore, Lorain County Children's Services would request the court affirm the trial court's decision. Thank you.
Questions? Judge Ron? Judge Campbell? Question? Do you have a question for this counsel? No. Okay, yeah. All right, thank you very much for your argument, and we will hear from Attorney Rhodes for 1 minute, 49 seconds.
Thank you, Ron. As the court has seen from a review of the magistrate's decision, arriving at that decision, the magistrate totally disregarded the fact pattern that we had set out relative to what transpired after Mr. Radizak returned his children to Ms. Balzer on the 29th. More telling, the magistrate failed to even address the credibility or lack of credibility of Karen Balzer, which is a mainstay throughout this entire case. To reiterate, everyone that testified indicated that they testified predicated, at least in part, on what Karen Balzer told them. We submit to the court that this is reversible error. The appellee argues that the trial court is in the best position to ascertain credibility of witnesses. And for the most part, we would tend to agree with that. But in this case, the magistrate surrendered that responsibility to the prosecutor's office. The magistrate didn't draft this decision. The prosecutor did. The only changes that the magistrate made were to deprive my client of any visitation with his children. Further, it is our contention that the appellee in no way, shape, or form arrived at a change of circumstances. Never happened. There were various mentions from Otero, they just didn't get along. From Stopper, well, he didn't communicate with her. It was inconvenient. I suggest that this is not a change of circumstances, and the best person to have custody of those two little girls is their father, who cares for them and has always cared for them. Robert Radizak. Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement and issue a decision which the clerk of courts will mail to you on the day it's released. The opinions are also posted on the Supreme Court of Ohio's website. So keep an eye out there. Again, we want to thank everybody for the arguments that were made and presented this